you for joining our live stream today. The European Commission is due to publish on 9 December its proposal on a Digital Market Act and also a proposal for a Digital Services Act. So it's very timely that CERRE comes out with today with an important book, which is entitled Digital Markets and Online Platforms, New Perspectives on Regulation and Competition Law. This is a book, and we call it the CERRE Platform Book, which is a snapshot of our think tank's contribution to the debate on the regulation of the online platform economy, which has been going on for a number of years already. And more precisely, what the book brings is an impressive series of concrete recommendations to policymakers drawn from some of the most relevant pieces of research on the subject, which have been completed by the CERRE academic staff, and that has been published by CERRE in reports over that period. You'll find in the book analysis and proposed options on the most adequate policy and regulatory framework to make digital markets competitive, safe, fair, and innovative. And we deal with a variety of relevant topics, from market definition and market power to non-discrimination, from acquisitions to data portability and the roles of data and data sharing for digital markets contestability, and from remedies to a variety of other topical issues. And that work builds up upon not only a robust analytical framework, but also on the collective expertise of our industry, regulatory, and academic members. And of course, it's been completed while scrupulously upholding all researchers' full academic independence, which, as you all know, is enshrined in the bylaws of our think tank. You can download the book from the events page and publications page of the CERRE website. And I really invite you to consider the CERRE platform book as a key resource, as well as drawing from the findings from the previous reports I mentioned. It contains newly curated editorial content, a foreword by me, and an introduction by the book's editor or co-academic director, Professor Krämer, who is with us this afternoon. And before starting the debate with a most interesting panel of speakers that I will introduce, whom I will introduce in a few minutes, I'd like to invite immediately Jan to present our new baby. Jan, the floor is yours.
Thank you very much, Bruno, for the introduction. So I have the pleasure of presenting this work on CERRE's platform recommendations, and it's really not my work, it's really the work of the whole team. And if you would compile all of these together, you would have more than 1,000 pages of recommendations. So let me first start by introducing the key economic issues that we address in these reports, and also the key characteristics of platforms that are relevant to these reports. First and foremost, and this should be maintained by any regulatory intervention, is that platforms are powerful engines of growth and innovation. So that must be preserved. But at the same time, we know there are some particular economic issues, like very strong network effects and winner-takes-all markets phenomena, which make markets tip in these platform markets. Then there's the multi-sidedness and the issues that come along with the determination of relevant markets and the determination of market power. A lot of times these platforms are vertically integrated, and there are potentially issues of self-preferencing. And they have, a lot of times, these are based on data-driven business models and data agglomeration. And the key question is, how can we make use of that data also outside of that platform? Now, CERRE has done a number of reports on these, which you can sort of see the front covers on this page here, pertaining to data sharing in digital markets to maintain the contestability, identifying the key role of data, in these platform markets and how they relate to innovation and contestability, then issues of data portability and how it can be made more effective, big tech acquisitions and mergers, market definitions and market power, implementing effective remedies, especially in the context of self-preferencing platforms, and more generally also on internet platforms and non-discrimination. Now, I should mention two main economic policy goals that are sort of overarching above all of these CERRE works, which is that because market tipping is almost inevitable in platform markets, and there are also quite a lot of efficiencies involved due to these network effects and also data agglomeration potentially, that we believe that the focus of the public policy debate should not necessarily be to prevent tipping of any market per se, because that is a lot of times inevitable because of the economics involved, but rather first to ensure two things. First, to ensure fair and transparent competition happens on the platform. So this includes also the possibility that new platforms can grow on an existing platform. For example, a dominant app store could be contested if apps that are app stores themselves were allowed and could grow within the dominant app store. And second, policymakers need to ensure that new and emerging markets, which occur all the time, remain contestable to entry for both existing and new players. So the focus here should be on new markets that have not yet tipped, with the goal that new players can grow to size themselves, create more diverse competitive landscape eventually, and also a landscape in which data is not agglomerated by just a very few firms, and market power is agglomerated by these firms, but is spread out across a number of services more equally. So ultimately, in this way, if there's enough sizable competitors, they can exert enough competitive pressure also on tipped markets. We make, in this platform book, along these different reports I've mentioned, we make three key recommendations, or recommendations in three key areas, I should say. First, relating to more effective enforcement. Second, relating to more transparency and switching. And third, to access to key innovation inputs. Let me briefly go through all three of them. First, relating to more effective enforcement. Here there are three subpoints I want to make. The first relates to market power and the determination of market power and in these markets. I already addressed that there's multi-sidedness, and this needs to be taken into account when defining market power. It's not enough to just look at one side of the market to determine market power of these multi-sided markets. So particularly viewing market shares as a proxy for market power, which is often done in standard markets, should be viewed with a lot of caution. If such shortcuts are taken, it's much better to use usage volume or revenue shares to determine market power in platform markets. The second point relates to updating merger control. And here particularly focus should be on potential competition and the control of innovation capabilities rather than on existing competition as is usually done. And the third relates to remedy design. Remedies that can potentially fix some of the issues here after a competition case has been made are necessarily very complex, and a lot of times it's not easy to foresee ex ante what a right remedy might be. So here we suggest that there should be more field experiments by authorities, so experimental enforcement, where the appropriate remedy and the effectiveness of remedies is tested really together with the firm that needs to implement this remedy. This might also relate to regulatory sandboxes that have to be put in place while these remedies are designed together with the regulator. Now, the second main area in which we make recommendations is with respect to increased transparency and the ease of switching. Now, the first relates to transparency. For example, here we mean transparency, how rankings are determined and how prominence of content providers is determined on the platform, especially for own content and services, but also for sponsored placements. So here we recommend that for large dominant platforms, that transparency must be done in more detail than what is currently prescribed in the platform to business regulation, because such information can be business critical, and therefore it cannot just be made public generally. We argue that such increased transparency should therefore predominantly be done with respect to the regulator and not the general public or other businesses. And also importantly, such transparency can also act as a coercive regulatory device, which sort of prevents abuse before it actually happens. But if there is some abuse, the continuous monitoring that comes along with these heightened obligations and the data collected in the process will be very useful to actually speed up the competition procedures so that remedies can be devised much faster, which is one of the main problems we see today. The second issue here is with respect to facilitating switching. So going beyond the provisions that we already have in the General Data Protection Regulation, which relate to personal data, we argue that continuous and real-time data portability of data that has been provided explicitly or implicitly, for example, through clicks and behavior to a platform, should be made possible, but not only limited to raw data, not to refined data. And data portability should also be facilitated for business users, and not only related to personal data, but also related, for example, to campaign data and other business data that businesses have provided to the platform. Now, the last area is providing access to key innovation capabilities. And here I want to particularly speak about access to data. So we detailed in some of the reports how exactly data is used to derive competitive advantage and how their data can facilitate innovation on key platform markets, such as search, e-commerce, and media. And while doing that, we came to the conclusion that raw data on consumer behavior, both explicit and implicit data provided by consumers, is a key innovation input, and it should be shared in some form. Now, we lay out two modes how data can be shared. The first is data sharing in bulk for a quite narrow set of gatekeeping platforms. And this may well involve vetting the firms that receive the data, and it might also involve tailoring of the data sets that are made available. And it might also involve institutional frameworks that need to be put in place to be able to share that data in a secure and privacy-preserving manner, for example, through data trusts. And the other mode is data sharing through continuous and real-time data portability, very much in the sense that I talked about before. And the advantage here with data portability is that this is user-initiated, and therefore privacy issues that might arise more so under mandated data sharing are less of concern. Of course, data is not the only resource necessary for innovation. Also, computing resources, access to skilled labor, and risky capital are also necessary. But here we haven't done a detailed analysis in the platform book as such. Now, so let me wrap up the main conclusions. In a nutshell, we think that a gatekeeping platform should be subject to some heightened standards of transparency and also closer monitoring, particularly vis-a-vis the regulator, and also be more transparent with respect to designing and implementing the remedies, for example, through experimental regulatory approaches and field tests. So second, data sharing of raw consumer data is seen as a vital means to enable access to key innovation and key competition resources. But of course, sometimes this will not be enough as such. And finally, and this is an additional point I'm making on this slide, is that there needs to be more harmonization in the regulatory framework, moving more towards a horizontal rules or cross-industry rules and less to sectoral rules, as the boundaries between sectors and also the boundaries between legal realms, for example, data protection and competition, become increasingly blurring in the digital space. So this is a point, however, that cannot be addressed in the short term, certainly not in the Digital Markets Act that will be unveiled shortly, but it needs to be addressed a little bit more in the midterm. With that, I thank you very much for listening to the presentation, and I'm looking very much forward to the debate that we're going to have.
Thanks a lot, Jan. This is a great presentation, not least because it's synthetic and it sums up in 5 slides, I think more than 1,000 pages, 1,000 pages of,
yes.
very detailed work. So great job. And before we kick off the conversation with the panel, I'd like to tell viewers that they're encouraged to ask questions, and you can do that via Slido with the code hashtag CERRE Digital, and you see that behind me, that's here. Voilà. Alors, to discuss the issues around the online platform economy and its regulation, because this is basically what this book is about. I'm very pleased to welcome three great panelists: an MEP, a regulator, and a journalist in a global media. So Stéphanie Yon-Courtin is Vice President of the European Parliament's Committee on Economic and Monetary Affairs. She's a former competition lawyer. She's, I think, also a former regulator, because if my memory is correct, she has worked in the Autorité de la Concurrence Française. And she's, and that's why also we are very happy to have her this afternoon, an active contributor in Brussels conversation on how the Parliament will approach its co-decision role for the upcoming DMA. So, bonjour, Madame la députée.
Bonjour, Monsieur Liebhaberg.
Alors, Yvrande-Billon is the Director of Economic, Market and Digital Affairs at Arcep, which is the French regulator for electronic communications, and also a member of CERRE. Anne was already part of the CERRE community in the job that she had until recently, which was the vice chair of the French railways and roads, and probably a number of other added sectors regulator, the ART, and ART is also a member of CERRE. And Anne was a professor of economics earlier in her career, and she also worked at the French Competition Authority. Bonjour Anne.
Good afternoon, bonjour tout le monde. Merci de me recevoir. Thank you for your invitation.
And our third panelist is Javier Espinosa. Javier has been following us previously. I noticed that in previous webinars that I did, he was sending questions for Mark Zuckerberg or Breton. You certainly remember very, very difficult questions for the moderator to ask. We may discuss that some other times. And Javier is covering the busy and demanding Brussels beat for competition and digital policies for the Financial Times. And we will highly value Javier's insight on how analysis-based top quality global journalism with extensive readership in the US and in the UK, as well as in the EU, is looking at Europe's endeavors on platform regulation and competition. And I'd like to start with you, Javier, because I understand that unfortunately you cannot stay very long with us because there is a breaking news you have to write upon. I'd like to start with the Brussels effect. You know, everybody knows the Brussels effect. Anu Bradford came up with this, the process of unilateral regulatory globalization caused by the European Union de facto externalizing its laws outside the borders through market mechanism. So I'd like to ask you, Javier, do you see that the work on platforms, which is occurring in the Union, do you see it having an impact, for instance, in the EU and in the US? And I'm referring, for instance, to the various initiatives that are going on in the US with the 48 state general attorneys work on Google and Facebook, the FTC, the Treasury. So any relation you see? Can you share your view on that, Javier, please?
Absolutely. Thank you so much for having me. I have to say it's quite weird to be asked the question. I usually feel more comfortable asking the questions because then I don't have to pretend that I know too much. But and on the breaking news story, you can read about it tomorrow in the FT. The short answer is that definitely, you know, just as the EU is moving to create new rules for gatekeepers, We see that the US is just only opening an antitrust investigation against Google in the way that the EU did 10 years earlier. So in a way, that can be just a factual point to show that the EU is looking to be at the forefront of big tech regulation. And for me, it has been super interesting. I've been here in Brussels just a little over a year. And in a way, I picked the worst year and the best year to be here, the worst year for obvious reasons. And then I hope that one day we can have some cookies and coffee after this session, you know, in real life. But the best year, because I have been able to experience firsthand as a total outsider. I'd never covered regulation before. I was writing about deals and M&A and private equity. And you can see that it's just like from the ground up, how the EU is looking to regulate big tech. And so far, it's quite interesting because, you know, usually when we write about this subject in the FT, we look at the political dimension, not just sort of like the process and the technicalities and, you know, the different DGs and which commissioner is doing what, but just about what it means in the global context. And I think it's been quite interesting to navigate, you know, talking to people on all sides, from like the member states, big tech, the commission, and understand that even within the commission that it's looking obviously to have this big goal of coming up with new rules for the first time for large platforms in the last 20 years or so. Even within itself, there are contradictions or limitations or delays. For example, you know, we saw that we were expecting draft regulation of both the Digital Services Act and the Digital Markets Act earlier in December. It's now moved. It's been so interesting as well to chronicle the tensions between the EU and big tech. You know, only recently at the FT, we had front page stories about Google targeting Commissioner Breton directly, so that gives us a flavor of just how these big platforms really care about this regulation that arguably will tackle or affect the core of how they've been making money over, you know, since their inception, their conception. But maybe I'll stop there. I don't know if there's anything you want to.
No, thank you. I'd like perhaps we'll get back hopefully to you in a minute, but I'd like to turn to Stéphanie Yon-Courtin. I think you also chair, among your many responsibilities, you chair the EU-Canada delegation in the European Parliament. And I would like to ask you whether from a global perspective, how would you compare the European approach compared to that of other regions? Do you discuss, for instance, with your Canadian colleagues, these big tech issues? Have you had the opportunity to discuss that with them or with other colleagues from outside the EU?
Well, as you said, in my previous life, I used to be part of the regulator. And first and foremost, thank you very much for your very invitation. And in this time with my regulator hat, I used to discuss a lot about comparative antitrust around the world, because it was my job basically to be international advisor for the chair of the French Competition Authority. And we had this discussion and clear, well, we are starting now to discuss more detailed questions on digital with the Canadian colleagues, like artificial intelligence, GAFAs and stuff. And I must admit, I do share what Javier has just said regarding the fact that the European Union is really at the forefront of the reflection on having an ex-ante regulation, having a proper regulation, tackling GAFAs and gatekeepers, basically, and really for a change somehow, because we're having the kind of habits to see all the time the United States or North America being really precursors and always always having the leading the way, let's say, in these and even in antitrust. But now, I mean, and it's very, very interesting to see how the European Union is just, as yesterday Vice President Commissioner Jourova said, we're just paving the way for the European digital soul. And I think it's very, very interesting and very inspiring to see how far we can go, hopefully, because we haven't got the final draft yet. We still don't know whether it's going to be a Christmas tree or a Christmas present. Hopefully it's going to be for 2020. At least it will give us an opportunity to do something in Christmas, because we don't know whether we will be confined or not. So I hope I will have this, very interesting draft to discuss with my friend or with my Christmas tree alone. But no, yeah. Back to your questions, definitely. I mean, the Canadian colleagues are very interested and very curious. So I think definitely. I mean, and the Chinese as well. You know, we're going to have a big European and Chinese week again in the following months. I think it's going to be in February again, and I know they are very eager to knowing what's going on in this regulation Christmas tree. So. Well, let's now suppose that we're going to have an ambitious regulation, and I'd like to thank and congratulate Professor Jan Krämer for the very interesting suggestions, and I'll be ready to discuss this further with you.
Thank you, and I'd like to pick up on what you just said now. I mean, we heard from Jan that there's still many areas to explore to make digital markets more competitive, safer, fairer, more innovative, etc. So I'd like to ask the three of you, what should, in your view, be today the EU's top 3 priorities in making this happen? I don't know if you have to leave it in 2-3 minutes, Javier, and if you want to respond, now's your slot.
Well, I don't know if I have 3, you're putting me on the spotlight here, but I think the first thing is that the EU must agree with itself about what the priorities are going to be and present a united front, because as we have seen from the digital players, they are unpicking areas of division. And if you're coming out with what is arguably like the most ambitious set of new rules and regulation that you are going to place on the biggest companies in the world right now, you have to really come out and speak with one voice. So I guess the concern that I'm picking up from people right now is that you have this deadline of December the 2nd, then it moves to December the 9th. Arguably, this is not going to matter in 3-4 years' time if you get it right. And so maybe, it might, as frustrating as it may be, basically get the house in order, just to steal the metaphor from Madame Yon-Courtin, if it's not going to be a Christmas present, maybe, make it a New Year's sort of resolution or something. I don't know. So I guess this would be for me the big priority. Then you get into the granular detail about what the regulation is going to look like. But yeah, I guess that's the big picture at the moment and the big concern that I'm picking up from people.
Thank you, Javier. And from your perspectives, what if you had to say, okay, for me, the 3 most important points, the most important priorities are the following. What would those be?
Thank you very much. Thank you very much for inviting Arcep to participate to this roundtable. I think there is one big priority that embrace several different topics, but the biggest one, the most important one, should be to give ourselves sufficient means to tackle the various and very high barriers to entry and market failures that have been very clearly, and thank you for that, identified and summarized by Jan in the book. So we have multiple barriers to entry, multiple market failures. Some of them are kind of new. And the old tools we have, you mentioned, Jan, the difficulty to use the relevant market framework, for instance, because of the two-sided aspect of these markets, but also because these markets are very fastly evolving. So we need to be able to adapt a lot. This means having a lot of tools, new tools. So the biggest priority should be to give ourselves sufficient means in terms of tools, in terms of expertise and resources in these data-driven markets. One of the aspects to tackle the issues you've mentioned is to be able to have a data-driven regulation. So this need for regulators or for the level of intervention we have, this means to have expertise in of course, engineers, but also data scientists, data crunchers, behavioral economists too, because these are new issues. So I would summarize by one big priority, but it's a big one. Give ourselves enough means to tackle with these new issues and big ones.
Thank you. Thank you. Clearly, we recognize the consistent line from Arcep, innovative, regulation by data, and we recognize your something that has been advocated already a few years ago by Sébastien Soriano, and that's very interesting. Stéphanie, Yon-Courtin, what would be for you the three priorities? You are very much involved in these dossiers. What are for you the three? What would you like? Let's put it this way. Let me follow up with your Christmas tree. What would be your best presents for Christmas in the DMA and the DSA?
Well, before the Christmas present, I would put, let's say 4 balls in the tree. And I thank Anne, because since she's got only one priority, I can take one back from me. So thank you very much. That's how ladies work together, are very, that's solidarity, solidarity spirit and girl power. Well, no, I think the first thing, and it's echo what Margaret Vestager recently said, it's time to act. It is time to act. Time is of essence in digital markets, and we cannot, afford waiting 15 or 20 years to get a case solved. I think it's very important because we experience enough waiting some years to open formal investigation, to end up with a fine that sometimes wasn't deterrent enough, and 5 extra years sometimes to implement remedy that were even not necessarily working. So this is the first thing. And I think the second really important is the solution will be twofold. Somehow ex-ante regulation is not a magic wand. So we need ex-ante regulation, targeted one, swift, precise, concrete, but we need to adapt competition law as well, and at the same time. And because it has to be adapted to digital challenges. And it's very important because I think if we would have in the past used more of this competition toolbox, then we wouldn't have this reflection, that big reflection now. I think, we should use more interim measures, like in France, for example. I think interim measures are key. I mean, they're a real effective way to prevent unfair competition, more targeted behavioral remedies. I echo what Anne just said. We have to make sure that we have the sufficient and adequate means to address competition issues, and with competition experts, that's definitely important. We have to review, and this is what Professor Jan Krämer said as well, and it's very interesting, review our law dedicated to the digital age, like European merger control, market power, market definition. The third big priority, I would say, is flexibility and fine-tuning, because we need to design an agile and future-proof regulation. You know, digital markets are evolving so quickly. It's very hard to predict how they will evolve, but if we want to maintain innovation, then we have to make sure it's future-proof and fit for this digital age. And last but really not least, I think the DMA, because as part of this big package, we'll have DSA and DMA. The DMA must work on these two legs, namely regulation, having a proper set of regulation, ex ante and competition, but also ensuring a perfect and effective enforcement. And this leads me to what Professor Krämer highlighted. And the key element of this, of course, is the institutional design. I think this is key. Leaving the enforcement to national authorities without a European supervision is definitely not an option. Creating a 53rd authority is not at all, you know, that's what General de Gaulle used to call a machin. But we need, I think, to think and get inspired about what the European Competition Network has achieved so far, and maybe think about more than competition, a bigger interplay between the competition world and the national regulators, national competition authorities, the market actors, to make sure we have this huge European task force able to enforce this set of rules.
Thank you. Let's pick up on what you just mentioned, and which is basically the regulatory design. Clearly, a lot of the efficiency of the new rules which may come in will depend on the way they're being implemented. And the first question is to know who's going to implement them. So I'd like to ask you, Anne, what is the role that you see for national regulators to deal with platform regulation? And what kind of national regulator is this? Do you think that Arcep, that is a telecom regulator, and the Arceps of Europe would be in the best position to handle the regulation of online platforms? Do we need an EU regulator? Do we need to create what Stéphanie called un machin, referring to de Gaulle, but fortunately there's no empty chair this time. So do we need another machin, or do we need to build up upon the existing system with, for instance, DG Connect or DG Competition? Do we need a global regulator? I mean, I've got tons of questions on that. So let's start perhaps on what role for national regulators, and what is a national regulator who would be the more adequate to deal with the issues?
Okay. I thought you were going to stop your question after what is a regulator. So we're thinking about a very long answer. Now, no. I agree that there's no doubt that regulation must be at the EU level, because the actors are at least at the EU level. So there's no doubt on that, regulation of digital platforms, structuring platform must be designed at this level. But it doesn't mean that there's no need for national public bodies, national regulatory authorities. And because I've mentioned the need for expertise, and I've strengthened the importance of this kind of means competencies, but also in line with what Madame Yon-Courtin said, the need for adaptability and continuous monitoring, which was highlighted by Jan also. This is where what we call ex-ante regulation is. It is the DNA of national regulatory agency to build this continuous monitoring, be able to implement it on a day-to-day basis. So this is an important aspect. If you need flexibility, and because you need to be able to be aware of the new things happening of this market, on the more recent evolution, a day-to-day control and monitoring, a continuous interaction is needed. So that's where the expertise of national regulatory agencies may be interesting. But the other reason why and where I see a role for national regulatory agencies on that matter is for instance, on data collection again. So it's not it's not an obsession, but this data collection is required, and these competencies of collecting data, of using them, collecting them, using them, is something that already exists in national regulatory agencies. There are also initiatives like the Center for Technical Expertise for Digital Regulation in France, PEREN, which has been set up recently. So that's where our competencies could be required. The other example I see where national regulatory authority could be of great help is in case of dispute resolution. We could imagine, well, dispute resolution mechanisms should be set up, and in that case, there may be a need at the national level for relays to collect complaints, because your market or your actors may be at the European level, but you may need to have a door at the national level to which people can knock at and explain their complaints. So that's where I see the expertise of national regulatory authorities.
Okay, thank you. Now, turning to the need or not the need for global regulators, Stéphanie Yon. Do you think you?
Yeah. Well, I think definitely, as I said, and it's very well underlined everywhere, and I'm sure I will be happy to hear Professor Krämer on this. But I think it's key. It's a key element of the enforcement in the institutional design. As I said, leaving the enforcement to national authorities, whatever they are, without any European supervision, is definitely not an option. We cannot afford having, like, a race to the bottom and having loopholes exploited by platforms, because it could refragment the market again if you divide the regulation by multiplying the regulators. I understand and I agree with what Yvrande-Billon said regarding the fact that when it comes to dispute resolution cases and collection of data, you need the expertise of people on the ground, and it's very important. So, because platform regulation is, as at the core of platform regulation, you have competition issues, but not only. You have also many issues on consumer protection, on digital sovereignty, on telecom, on industrial policy, on data protection, on internal cooperation. So I think competition policy should be the link maybe to all these policies and their relevant coordination mechanism. If you, for example, you can get inspiration from the BEREC, which I think wasn't that sufficient enough, in terms of enforcement, but just as a forum, European Consumer Protection Network, the European Data Supervisory Board. So I think before, creating from scratch a European regulator, I think we have to make them work together. And in my opinion, as I said, European Competition Network is maybe the most achieved network with a clear framework and an objective, with an objective to harmonize procedures and sanctions. So I would argue to bring all these stakeholders under the same roof, to break down, and I think it's very important in this matter, to break down the silos and collect all the relevant market information in order to implement properly the regulation. And I think also DG Comp so far has a good experience in terms of enforcement. So, I think all these networks, regulators, European and as well as national ones, could be a good set of good institutional design.
Okay, I'd like to turn to Jan Krämer. on this the regulatory architecture. What are your views at this stage, Jan? And perhaps if you could shed some light on what is the feasibility of having a global regulator? Because, you know, we're talking about global platforms. So is this something which makes sense?
Yeah, thank you, Bruno. So not surprisingly, I don't have definitive answers either, but I very much agree to what has been said. So first of all, in terms of priorities, I think, you know, I presented a list of 3 priorities or 3 areas in which we make recommendations. And there were first, more effective enforcement, second, transparency and switching, and third, access to key innovation inputs. And I would say this is also the order in which we should address them if we cannot address them simultaneously. So more effective enforcement really is at the core. Now, relating to your question, so where should the regulator be and how centralized should it be and how global should it be? I very much agree with what has been said. First of all, it's clear that, you know, we need some centralization because these platforms are not national platforms. And we've also seen that if we try to address this on a purely national level, there's going to be fragmentation in the rules. There might also be that some of these regulators, these national regulators in which these platforms are then based, become overwhelmed with the workload that they need to handle on this. So I think a way forward might be that we do have some central instruments in Europe. And the question here really is, what does it look like? Is it a forum? Is it potentially a new regulator? But then we would probably have to renegotiate the treaty, which doesn't really seem feasible these days. Although on the other hand, we're sort of becoming increasingly good at renegotiating treaties in the context of the UK, I guess. But in any case, so there needs to be some centralized forum, because also there needs to be some centralized expertise, as has been laid out, which then needs to be shared. But I very much agree with the fact that this decentralization, the role of the national regulatory authorities, is helpful in at least 2 ways. First of all, they have this experience in terms of monitoring that has been said before. And second of all, it's also they can share sort of the burden of enforcement among the member states. So you don't have sort of this central bottleneck, you know, where all of this comes in, but you can really have a coordination, a central coordination, but then a sharing of sort of the enforcement burden and the manpower also, and the woman power that comes along with it. Now relating to a global regulator, that I don't believe so much in. I think if we would really achieve something at a European level, with the economy that we have and the number of people that are addressed by this, it's hard to come by Europe. Yeah, we talked about the Brussels effect in the beginning, so we're already having sort of a spillover effect to other nations. And yes, it would be good to have some harmonization there as well, but we should really stay with this within the realms of Europe. And we see that even on other issues that we potentially can agree on more easily, like climate change, right? So the global scale is a little bit more difficult to actually make meaningful progress here. So some coordinated instant at the European level, collection, aggregation of expertise also at the European level, and then sharing of burden on the national levels is, I think, the right way forward.
Thank you very much, Jan. I remind viewers that we are expecting their questions on Slido /CERRE Digital. I have a number of questions which are coming in, which I see popping up on my screen. I'll perhaps take one from Felipe Flores Duncan, which says, regulation works best in markets that are predictable. However, digital markets are fast moving and unpredictable. How will this tension be reconciled? And how do you look at that? You are trying to catch something which is like sand. It's moving. It's a moving reality. How can the tension between the fast moving and unpredictability digital markets and the need for a stable, efficient regulation, how can you overcome that tension?
Well, I think it's a tension, or it's a difficulty for all types of agency or regulation, whether sectoral, ex ante or ex post. By definition, an evolving and continuously evolving market implies some kind of uncertainty and unpredictability. The thing is that the more continuous the relationship you have, and the better knowledge you get from the market and the market players, the interactions you have, and once again, the expertise may help you to anticipate, but no one can anticipate all the future, especially on this market. But I think some sectoral regulators, not only in the telecommunication, but it's their job in a way to thanks to the knowledge they have, the expertise they have on the markets, and the day-to-day interactions, they may be better placed to anticipate and provide to the community the results of their thinking on the potential evolution of the market. And obviously, the second aspect of the question is that there may be a tension between the need for stability, or sometimes the preference of regulators and administrations as a whole in general for stability, because that's what they're supposed to provide, some kind of stable framework, and the definition and the nature, the DNA of these markets, which are evolving. So that's where the difficulty lies. I agree. That's why one option and one possibilities we discussed in Arcep's different contribution to the debate is the fact to have on a mix, a combination of principle-based rules, the classical tools remedies we use in our ex-ante approach. Let's talk about transparency, non-discrimination, codes of conduct, things like that, as well as case-by-case remedies or tailor-made remedies, to be able to be more flexible. So there is a framework with general principles, and there may be case-by-case remedies depending on the knowledge and on the level of precision you have on specific cases. So this is a difficult trade-off to make, or combination to make, but that's how we see things, and obviously it's not an easy task.
Thank you, Stéphanie. Have you got a view on that tension between?
Yeah, well, I mean, obviously, fast-moving markets and the reason why we need to have these fine-tuning and flexible tools. This is the big dilemma, actually. What is how to strike the right balance? Digital markets are evolving, as we've just said, very quickly, and it's very hard to predict how they will evolve. Somehow, it's a positive sign of innovation that we have to maintain, and that's where lies the Digital Market Act. It's going to be a challenge, as it will be very hard to strike this balance between regulation for systemic platforms. So, and in order to ensure fair competition before any abuse and any anti-competitive practice, and race to innovation. Because first, and I think we have to repeat that, it's very important to know that, to recall that we all acknowledge the role of big platforms and the importance they have in the digital ecosystem for many companies. So, I mean, it's not a regulation against big companies or against platforms, because otherwise it would definitely lead to, a regulation against innovation. But in this perspective, the scope with the definition of gatekeepers will be very crucial, as well as all the criteria we will use, quantitative, qualitative criteria that the Commission is currently struggling with. This is very important, and that's why fine-tuning, finding the right tools for ex-ante rules, very transparent, clear regulation, and I think very swift tools, so that they are to have a future-proof somehow regulation that will be easy to adapt to this fast-moving market.
Okay, thank you. There's a question from Samuel Sultan from Euractiv, and it's to you, Jan, but I'm not sure, I will read it, but I'm not sure you will be able to answer it. I'll explain. The question reads as follows: surely the most important point for the EC to consider is how to define a tipping market in the digital economy. What could be the objective criteria include? Well, Sam, others, dear friends, next week, and this is breaking news, CERRE is going to publish its recommendations on the DMA. And clearly, this is going to be one major part of our recommendations. So if you could bear with us just for a few days, and you'll get the answer next week. And I hope, Sam, that we'll be able to discuss this with our colleagues and you. So I have another question from DuckDuckGo, which asks, are preference menu like what Microsoft introduced at the time, browser choice screen, a good solution to substitute default settings by gatekeepers? I don't know who wants to answer that. Jan, perhaps?
Yes, I might well go. I mean, generally speaking, we know that there are a lot of behavioral biases also in the digital world. And so anything that platforms do at their front ends, it has gone through tremendous experimentation before. They have a large user base, so they can just present one way of it and another way of it, and they will choose whatever suits their goals best. So every design on the website is very deliberate. So if some large players pay huge amounts of money to buy into defaults in browsers, for example, then this is done for an economic reason, obviously. So defaults are very, very powerful. Now the question really is breaking these defaults. How do you go along? Because also, and this is sort of the tricky part about this, there is also here some inherent efficiency involved in the defaults. One is sort of this positive feedback loop by data. As you're a large engine, you get more data. For example, a large search engine, you get more data. As you get more data, you can improve sort of the results a little bit better, particularly on, and this is a point we make in one of the reports as well, particularly on infrequent searches. So search terms that have not been seen before, or search terms that are new. So this is the tricky part of predicting. But as you get sort of more users, you can do this better. And so having a default also has some efficiencies. But at the same time, it makes it very, very difficult for competitors, like a company like DuckDuckGo, for example, to sort of get the sufficient user base of their own. And there are several options. One is to sort of have choice menus, which means that you sort of consumers, and I agree that to some extent we need to have this in a more transparent way. Then you set up a phone. You need to be asked explicitly what is the search engine that you want to use. I don't, the tricky question is how many times you want to repeat that choice and force it upon the user. But that choice certainly needs to be made at least in the beginning. But then also another possibility is, which we lay out, to share potentially more of that data in some ways. So even if it goes to one large search engine, for example, then we can make use of these efficiencies and the nature of data, which is non-rival. So it can be used by different entities at the same time by sharing it. So I think the answer is to do both. First, do a little bit more of choice menus, not necessarily every week, right? Or every Monday morning that you're forced to select your search engine again, because then we're going to get the same fatigue that we have with cookies today. Where we don't pay attention to that anymore. So it needs to be in a maybe half a year or so. But then also we need to think about sharing these key innovation capabilities, as I said before, in some way. And there's possibilities to do so, we believe. Okay, thank you. We're moving gradually towards the end of this this discussion, but I still have a few questions. So I would like to bounce back on something that Stéphanie Yon-Courtin said when she said, we're not against the big platforms. We don't want to be against innovation. And I think this is, of course, a very important point. We know that, for instance, the Commission has been consulting quite extensively with stakeholders before
in preparing the proposals they're going to make next month. We in CERRE, we believe very much in the value of partnership dialogues between stakeholders, and in particular between tech and government regulators. We discussed that in particular, as I mentioned earlier, with Mark Zuckerberg and Thierry Breton. I'd like to ask, both of you ladies, a politician, a regulator, what do you think of the value of those dialogues between industry and regulators? Are they needed? Do they work? What is missing for them to be effective? Perhaps Stéphanie Yon first.
Yeah, thank you very much. I think you're right, and I think dialogue is crucial. And I'm really supportive to what we call participative antitrust. Self-regulation is too often self-serving, and competition policy, I think, is too slow. And I think we must find a third way. And I can recall the Nobel Prize Jean Tirole, who explained the virtuals and really the variable sides of the participative antitrust, in which the industry or other parties propose possible regulations, and the antitrust authorities issue some option, creating some legal certainty without maybe casting the rules in stone, and I think the possibility of error must be accepted, and so the regulatory innovation must evolve as the authorities learn by doing and slowly incorporate them into guidelines. So everybody's feeding each other, and it will, for instance, allow us to test the remedies and adapt them if they are not working, because I think this is a very important thing. If you take the Google case example, comparison shopping websites are still not happy with the remedies proposed by Google itself. It is not mystery to ask why. Will you sentence yourself to die? Of course not. And I might sound redundant, but I strongly believe that risk regulation should not be an opportunity to oppose big techs against SMEs, national competition authorities against telecom regulators, consumers organization against industry. I think it should be seen as a positive regulation, positive step to empower companies and consumers to benefit from digitalization. And platform regulation is not only a competition issue, as I said. That's why competition policy should definitely be linked to all these policies and their relevant mechanism. And those networks are all useful and able to detect all kinds of market failures. So definitely dialogue between industry and regulators is key. I would at the end also like to underline that we should not forget about consumers. If we do want to take back control of a big tech, it will be up to consumers to do so at the end. I think we have to realize the price we pay for the services they receive. We have to realize that the behaviors are key and have a strong impact on the ecosystem, and we cannot only blame big platforms for the shutting down of small shops. We also have to ask ourselves, what can we do to stop it? We as consumers. So it will be a collective work, and I think altogether European Union holds all the cards to pave the way for this trustful and fair internet, which is very important to to create, to build this European digital soul.
Okay, and as a regulator, you have of course large experience of dealing with stakeholders, and this leading to the concept of participatory regulation. What do you think about such concept in the case of dealing with platforms?
As I already mentioned, stakeholder contribution and consultation is a key. It was mentioned in the various questions and answers that were given, and it's very important. And this is what regulators are used to do: organize public consultation on several hypotheses or models of framework or remedies they have in mind, and they develop the arguments on the different remedies they have in mind, and then the results of the public consultation help building ad hoc remedies and adapting to the particular circumstances of the markets or of the market failures they are dealing with. So that's one point. The second point is regulators also use tools like crowdsourcing tools. So you may organize a collection of information coming directly from the consumers or the different stakeholders with new technologies. That's what Arcep did, but other regulators also use that. So public consultation of stakeholders to improve the efficiency, but also the acceptability of the remedies and solution you will have to implement is a key, and it comes along with once again, a continuous monitoring and a day-to-day interaction with the stakeholders, not only the operators, but also, and I mentioned the example of crowdsourcing application or tools with the consumers directly. Okay. As well, obviously, with public decision makers at the local and national levels. So we're quite used to such kind of tools.
Thank you. I think we still have the time for one or two questions. I have one here from Britt Hecht to Jan. How can mandatory data sharing be implemented and enforced? What building blocks need to be regulated? What institutional setup to supervise? You have at least 90 seconds to answer all that, Jan. Let's be generous.
Yeah, actually, I recommend to read our report on the role of data and sharing data, because there we go through the different proposals and how to do it. And of course, you need to square the circle somehow. Well, in this report, what we focused on was really, or what we derived as a result, actually looking at search, media, and e-commerce markets, was that consumer behavioral data really is of the essence in a lot of these innovation capabilities. I mentioned in search already, how you can sort of better your search results. In e-commerce and media, it's a lot about recommendations that you make for new content that is relevant. Now, if you want to share such user behavioral data, of course, is this a lot of times personal data, and it's subject to data protection law, of course. So you cannot just share it in detail. And the data you need to share needs to be detailed in order to be meaningful. So you need to be able to enable across user learning, so a broad representative data set, as well as within user learning, so a detailed data set. So in order to square that circle, we suggest these two modes of data sharing. One is this mandated data sharing in bulk, and this needs to be necessarily a little bit more aggregated and anonymized. And there are many ways to do this. So there's advances in differential privacy and things. You can do that. There's also institutional arrangements you can do in terms of data trust, for example, that you give it some data intermediary. And from there, it's sort of the analysis is done. So this is one way. And the other mode of sharing is, and this relates to the important role of consumers and consumer choice again, is through data portability, that consumers actually initiate their data transfer. This is privacy preserving because it's initiated by the consumer itself. But in order for that to be meaningful, the data, as we said, data portability needs to be able to do in a continuous and real-time manner. It's not enough that you ask for your data and 30 days later you can download a zip file and upload it somewhere, but you need to be able to address this data through some interface and directly transfer it to whoever you see should be entitled to be getting that data. And putting those two modes together, bulk data sharing with a more abstract level, potentially also involving vetting of firms, and seeing who is getting the data. And the kind of data that they're getting might also be different in different instances, depending on what they want to do. And data portability, and that applying in a more broader set of firms. Those two together, we believe, can square the circle of sharing data while preserving sort of European values of privacy.
Okay, thank you, Jan. The last question will be to Stéphanie Yon-Courtin, but I think you've answered to some extent. The Commission inserts its action on online platform regulation within the framework of, among others, an industrial strategy which is geared towards enhanced competitiveness and digital sovereignty. You said already, I'm not, it shouldn't be a regulation against big tech, a regulation against innovation, but how important, how do you see the link between platform regulation and digital strategic autonomy? If you can give a brief answer to conclude this, I would be most grateful.
Just to make sure I understood well, because I had an echo and I'm not sure. So the question was relating to the interaction between regulation.
Is platform regulation a contribution to achieving digital autonomy, strategic autonomy for you?
Yeah, well, I think it's part of the it's not only the solution. It's just one means, one part of the solution to achieve at least what we call sovereignty or autonomy, or maybe resilience, digital resilience. I think it's not enough, and I think we have other tools in competition. For example, the EPCIs, this big project on disruptive technologies like batteries or hydrogen, which may be of importance to highlight the sovereignty of Europe. But when it comes to digital sovereignty, of course, platform regulation is not only a way to ensure fairness of competition and players in the internet, in the digital markets, but also to and to push for more innovation, and this combined with, as I said, tools like EPCR could be very interesting, and let's have other like horizontal and partnership between big techs and SMEs, for example, in certain, like for the 5G, in certain projects. And as I said, it's more a regulation for people, for all enterprises, for innovation and for consumers, rather than against. And I think people have to see this half full bottle rather than half empty. It's very important to see that this is an opportunity for us, and let's be ambitious. And I really, again, would like to congratulate Professor Jan Krämer for this very, very interesting book, and it's like a reference for us in the digital markets. And thank you very much, CERRE and Bruno, for this very stimulating and very mixed, because gender equality has been totally respected in this very stimulating webinar.
Thank you, Stéphanie. I hope you will all agree with me that this book and this afternoon's debate provide, I think, an additional illustration of the reasons for CERRE's ever-increasing recognition as a leading and pivotal think tank, effectively contributing to a regulation of digital industries which promotes innovation and promotes competition while helping EU citizens safely harvest the fruit of the digital economy. More than ever, we intend to keep up our efforts and live up to our reputation. We're continuing to map the path forward. And as I said earlier in this discussion, following this week's publication of our platform book, we will publish next week the very much expected CERRE recommendations for the DMA. And this will be followed very shortly after by the CERRE recommendation for the DSA. And obviously, we look forward to the reactions that those two publications will most certainly generate. On 25th this November, that is next Wednesday, we'll have another exciting webinar to present a new report on competition rules on cooperation for developing very high capacity networks. Confirmed panelists will include representatives from the Commission, DG Com, DG Connect, regulators, industry representatives, as well, of course, as the CERRE academics. And again, details are available on the CERRE website. We're really looking forward to it, and we hope to see you again at that occasion. So finally, before switching off, I'd like to thank wholeheartedly Stéphanie Yon-Courtin, Yvrande-Billon, Javier Espinosa, my CERRE colleagues, and in particular my liebe Jan, for who have made this event possible, and last but not least, you viewers, for your attention and for your support. Take care of yourself. Take care of others. Bye-bye.
Thank you. Bye.
Bye-bye.
Bye.
Bye.